This podcast is brought to you by the School of Advanced Study, University of London.
Okay, well, a very good afternoon to you all, and a warm welcome, especially in this sunny weather, which I know must be appealing to go outside and sit in a park. So thank you very much for joining us this afternoon. For those of you who don't know me, my name is David Cantor. I'm the Director of the Refugee Law Initiative here at the University of London. And this is the final session in a long series that we've had throughout the whole of this academic year, looking at different models and practices of refugee law and refugee protection in a variety of regional contexts. So we've looked at protection in the African context, in the European context, in the Asia-Pacific region, and now we come, after a number of detours, I think through the Middle East as well, to questions about refugee protection in one of the most influential states in the world for dealing with refugee issues, and that is, of course, the United States of America. And it's my very great pleasure this evening to present two distinguished researchers and academics, lawyers on this topic, who will be addressing you this evening on their research over the past 3 years in relation to some of the disparities in this field of study. A very brief word of introduction to both of our distinguished speakers. To my immediate right sits Professor Philip Schrag, who is the Director of the Centre for Applied Legal Studies in Georgetown University, which is a clinic that provides legal representation using students to those who are seeking asylum from persecution in the United States of America. As a practicing lawyer of, I think, some notes, he held numerous positions before moving into academia, including the Deputy General Counsel of the US Arms Control and Disarmament Agency. However, for the last 30 years, we've been blessed to have his mind in academia, and he has concentrated on a wide range of different research topics, ranging from consumer law, nuclear arms control, and finally to questions of political asylum. With Jaya, he's the author of two influential studies which form the basis for this evening's presentation. One, Refugee Roulette, with which many of you I'm sure will be familiar, which is on disparities in asylum adjudication, along with proposals for reform. And the topic of this evening's talk, Lives in the Balance, Asylum Adjudication by the Department of Homeland Security, one of the agencies looked at in the Refugee Roulette study. So it's my very great pleasure to welcome Professor Schrag here, and at the same time, to welcome our second speaker, or our co-speaker this evening, Professor Jaya Ramji-Nogales from Temple University School of Law. Professor Nogales is also a scholar and a practitioner of quite some note, and addresses a range of different research topics. I was particularly interested to see your first book was on bringing the Khmer Rouge to justice, prosecuting mass violence before the Cambodian courts, and it seems like it's quite a leap from that to looking at questions of political asylum. But of course, when one starts to get into the question, I think the links become very apparent. A great specialist not only on the issues that she studied jointly with Professor Schrag and also Andrew Schoenholtz in the two books that I mentioned previously, but also looking at the empirical assessment not only of the US asylum system, but comparative systems such as the Cambodian courts, procedural due process questions in the context of immigration and the intersection of that with international human rights law, and also questions of transitional justice. So you have two speakers addressing you from a wide range of expertise. So without further ado, I thank our distinguished speakers and hand you over to them. Thank you very much.
So thank you, David, and also thanks to Berenice Youssef, who made the arrangements for us today. David will leave you with a challenge while we talk of figuring out the connection between consumer protection and nuclear arms control and political asylum. The way we would like to talk with you today is to not just save questions for the end, although I'm sure we'll have some time for that, but to invite you to interrupt us with questions, and we may interrupt you with questions as well as we go along, because what we're going to do is present a lot of charts and graphs that have mysteries in them. And we are trying to, in our book, Lives of the Balance, trying to figure out the solutions to these mysteries. But you may have different solutions, and we're happy to entertain your theories as well as our own speculations about what causes some of the phenomena that you'll be seeing today. So, in the United States, we have domestic legislation called the Refugee Act of 1980, which is our codification for domestic law of the Refugee Convention. In the Act, Congress established a legal standard for granting asylum to people from other countries who are seeking refuge in the United States. And the standard is one that's familiar to all of those of you who know the Refugee Convention. The basic standard is, does the applicant have a well-founded fear of persecution on account of his or her race, religion, nationality, political opinion, or membership in a particular social group? I should add that our definition of a refugee differs slightly from the international definition in the Convention, in that the cessation clauses of the Convention don't apply domestically in the United States. But other than that, the standard is pretty much the same. The standard is applied in 20% of cases by immigration judges in the first instance. And that 20% is the people who are apprehended by the Border Patrol in the United States, who have no right to be in the United States, and they're detained upon apprehension. And they can seek asylum as relief from detention and deportation by claiming asylum before an immigration judge. But 80% of the cases, and this is the 80% that we've studied, are people who come to the United States and either overstay a visa, a student visa or a tourist visa or a business visa, or are in the United States without permission, just come across the border without a visa, and identify, in either case, identify themselves to the American government by affirmatively applying for asylum. And to do that, they fill out a form that tells the government all about them and their status in the United States and their identity and so forth, and it has many attachments, and they have to attach proof of their identity and their whole life story. The evidence that they have to attach, often in a successful case, runs to hundreds of pages of proof, not only of human rights conditions in their country, but proof that they were personally persecuted or threatened and have reason to fear persecution. So this may consist of, if they're well represented and if they have access to proof, may consist of affidavits, it may consist of arrest warrants that have been delivered to their houses, medical evidence of having been tortured and so forth. In an unsuccessful case, the person, typically a person who's not represented, and we'll get into the issue of representation, may have very little evidence and is likely to be denied asylum. But in either case, whether they have a lot of evidence or little evidence, there's 80% who apply affirmatively are, after they file the papers, are interviewed by an officer of the Department of Homeland Security, an officer called an asylum officer. And there are 8 regional offices of the department where these interviews take place. They're spread around the country. And a person may be interviewed, is likely to be interviewed in the regional office where the person applied. When a person applies for asylum, the person is photographed, fingerprinted, documentation is filed, and then the interview takes place. And in about 38% of cases, the asylum officer grants asylum to the individual and the case is over, about 38%. If the officer does not grant asylum, the applicant is served with a summons to appear in a deportation hearing called a removal hearing. And that takes place in federal immigration court, just as it does for a person who is arrested and detained before applying for asylum. And in that deportation proceeding, the person has a second chance to prove his or her case. This time, however, it's not simply an interview by an asylum officer. the person is lost in the asylum office of the Department of Homeland Security and goes to immigration court, it's an adversary hearing. And there's a lawyer for the Department of Homeland Security opposing asylum in most cases, vigorously trying to prove that the person does not deserve asylum, either because the person's lying, or can't corroborate their story, or even if the story's true, the person doesn't fit under this statutory definition, but is just an economic refugee, or a refugee from civil war, or from tornadoes or hurricanes or earthquakes or something like that, but not a refugee from persecution. In the immigration court, having a competent lawyer makes a huge deal of difference. We showed in our book, Refugee Roulette, that an unrepresented person wins about 16% of the time in immigration court. But a represented person wins about 41% of the time. And a person represented by a free lawyer, that is a pro bono lawyer for a big law firm, or a legal clinic for a university, or a non-governmental organization, such a person wins about 90% of the time, as opposed to 46% of the time for a paying lawyer. Much better to have a free lawyer than a paying lawyer you pay. Why? Because the lawyer that's free takes a much smaller caseload and puts a lot more time and effort into investigating the case and coming up with the necessary proof. But many applicants can't afford lawyers. They do not have a right to appointed counsel at any stage of the process. And at the asylum officer stage, the first stage, the one we've studied in this book, they don't even have the right to an interpreter. If they're going to have an interpreter, they have to bring their own. So if they lose in the asylum office, and the case is not granted, they go to immigration court. From immigration court, they can appeal to the Board of Immigration Appeals, another administrative body in the United States Department of Justice, like the immigration court, but relatively few cases get appealed that far because it's more expensive to take an appeal that far, and very few cases go on to the final possible stage, the U.S. Court of Appeals. That's an incredibly small percentage of cases that go into the system because it's quite expensive and time-consuming to go through the formal processes of an appeal to what is really the second highest court in the country, the U.S. Court of Appeals. In theory, one can appeal to the Supreme Court, but the Supreme Court only takes 80 cases a year out of 10,000 petitions. So only a handful of asylum cases have ever gone to the United States Supreme Court. Now, notice that this standard for granting asylum does not depend on certain things. It depends on whether you have a well-founded fear of persecution on one of those 5 grounds. But it does not depend on whether you entered the United States with a visa or without permission by sneaking over the border. It does not depend on whether you have a lawyer or not. It does not depend on whether you have dependents with you in the United States when you applied for asylum. It does not depend on whether the government official who interviews you for the asylum office is a lawyer or not a lawyer. It does not depend on the number of cases the interviewer previously decided or interviewed, or many other factors. And our study in this book, Lives in the Balance, set out to find whether factors like these, factors that are not in the statutory standard, factors that legally should not matter, in fact, affect the outcomes of asylum adjudications by the asylum officers in this first stage. So our primary source for our research was a government database of more than 383,000 cases. 383,000 asylum adjudications by the Department of Homeland Security's asylum officers from October 1st, 1995 to June 8th, 2009, a 14-year period. The data that we obtained from the government in this enormous database, one of the largest adjudication databases in the world, included factors like these: the applicant's nationality, the date of entry if it was known, the date of the person applied for asylum, the gender of the applicant, the age of the applicant, the religion of the applicant, if one was stated, whether the applicant came inspected, that is, with a visa or not, whether the person had representation, whether the person had dependents in the United States, which of the 8 regional offices the person was interviewed in, a code number for the adjudicator. We never got the names of the adjudicators, but there was a unique code number assigned to each. The experience of the adjudicator, that is, we were able to compute this, they didn't give us this, but because we had the identity of the adjudicator and could look at how many cases that adjudicator had decided before deciding this particular case, we could compute the experience of the adjudicator, the number of prior adjudications, and the outcome of the case. And of course, a serial number for every case. We didn't have the names of the applicants either, but they gave us a unique serial number for every applicant. So we had this enormous amount of data, and with such a large database, we could make the assumption, because cases follow similar patterns, that the individual variations from case to case other than these factors would wash out. So we could assume that every asylum officer who handled a large number of cases had the same number of truth tellers and the same number of liars, for example. Had the same number of good cases and the same number of bad cases as every other asylum officer with a large caseload. And we could look at whether things like the gender of the applicant made a difference from one asylum officer to the next. We supplemented all this quantitative research, which you're about to see, by interviewing asylum officers in each of those 8 regions, and also by talking to officials at the national headquarters of the Asylum Office in Washington. And we supplemented this research as well by looking at the results of a online anonymous survey that the Asylum Office administered to all of its asylum officers in May 2011 to ask them about certain things that were not coded in the database. In addition, so that was the full database, 383,000 cases. In addition, we had another database. It turned out that 31,000 of these cases were decided by asylum officers who had been trained at the Federal Law Enforcement Training Center in Georgia between 2003 and 2008. And we were able, and when they took the training, they filled out, on the first day of training, they filled out bubble sheets telling the training officers about themselves. We were able to get the results of those bubble sheets with the same identifier for the asylum officer as we got in the database of cases. And by merging the 2 databases, we were able to get some correlations, which you'll see at the end of this talk, between biographical information about the asylum officers, such as their gender, and the outcomes of the cases. They decided, the 31,000 cases they decided. We ran logistic regressions and or chi-square tests on all of the data we extracted from the databases, and linear regressions as a further check on some of them, so that what we're going to show you, all the graphs that we're going to show you represent statistically significant relationships between the dependent variable, usually grant rate, and the independent variables such as the amount of time from the person's entry until the case was adjudicated and so forth. If a result was not statistically significant, you're not going to see it. We didn't report on data that was not statistically significant. So here are the topics we're going to talk about. We're going to talk about, we have one slide on who these applicants were, where they came from. There's more information about that in our book, Lives in the Balance, but it's the rest of the stuff we have to say is much more interesting, so we're not going to tell you much about that. We're going to talk about the effects of a 1-year deadline on asylum application that Congress enacted in 1996, effective on April 16th, 1998. So we have data on the period of about 2 years before the deadline took effect and many years after the deadline took effect. And we have some information about the effects of this deadline. And then most of what we're going to talk to you about are decisions on the merits, decisions where the deadline did not exclude a person from having their case considered on the merits. And the kinds of discussion, kinds of variables we'll look at there are how the pattern of adjudications changed over time, how certain applicant characteristics affected outcome or correlated with outcome, what happened differences among the 8 regional offices, differences within particular regional offices, and characteristics of the officers themselves, this biographical information. We're only going to show you about 20 slides, because that's all we have time for today, but the book has about 120 slides. So if you want to delve more deeply into this, there's a wealth of additional information in the book, Knives in the Balance. So this first slide just shows where these applicants came from over a period of time. And you can see, just from the height of the first graph here, first set of bars, that Latin America, is it possible to turn off these lights without turning off all the lights, or?
We can give it a go, yeah. I think so.
You can see these graphs better if you just get some of these lights on.
Yeah, try some of
We can see it fine.
this. It's actually fine.
It's fine.
Yeah.
No problem.
Well, the print's going to get smaller. Let's try it with it off, if it's possible. Oh, good. Isn't that better? So you can see from this first set that Latin America is the single largest source of asylum seekers in the United States. But this tapered off a lot in the last period of the 4 periods we looked at, 2005 to 2009, whereas asylum seeking from East Asia and the Pacific, mostly China, was very small in the first of these periods, from 1995 to 1998, and then really took off and has remained high ever since. And that African asylum seekers have also been a very large aspect of asylum applications in the United States. So first, let's say a word about the one-year deadline. The book actually has 2 whole chapters of data on the one-year deadline. We're only going to show you 2 graphs today because this is fairly technical, and here in the UK you don't have a deadline like that, do you? No. Some people think, including my colleague here, that it's a violation of international law to have a deadline. But the government's rationale, okay, here's the government's rationale for why it's not a violation of international law to put a deadline on asylum application, the statute of limitations on applying for asylum. There's actually another source of relief in the United States called withholding of removal. And it's harder to get and gives you fewer privileges. And you can't get it from an asylum officer. You have to be referred to a removal hearing to get it and seek it from a judge. But the reason it's harder to get is you have to prove not only you have a well-founded fear of persecution, but it's more likely than not that you would be persecuted. It's a very tough standard, 51% standard to have to meet. And even if you prove that, there's no deadline on that. Higher standard, even if you prove it, you, unlike asylum, it's an impermanent status. You don't start on the road to US citizenship, and you can be deported at any time if conditions change in your country. And you can't travel outside the United States. You're marooned in the United States. So it's a less desirable form, but the United States says, well, our asylum deadline isn't inconsistent with international law because there's no deadline on withholding, and you can always get withholding if you have a strong enough case. So that's and their interpretation of the convention is that's all that's required. Yeah?
Sorry, I'm just curious, because you know the I-589 forms?
Yes.
I was wondering because don't you have a box on there to check whether you want to be considered for withholding?
Correct, but
And
the
it's clear to me
regulations
that
of
it doesn't go to an asylum
Right,
officer.
so the form goes to the asylum officer, but the regulations prohibit the asylum officer from granting this form of relief. The asylum officer, if he finds that you don't qualify under the well-founded fear standard, must refer you to a removal hearing, and there you can seek the withholding. It's a little bizarre.
Yeah, it seems weird they included it there.
Right. It's a little odd that the asylum officers are not allowed. And of course, it's much more expensive to have an adversary hearing than to have an asylum officer interview. So it's against the United States government's own interest to require all this additional time and effort to be put into adjudicating withholding, but there you have it. So until April 1998, there was no deadline for applying for asylum. 1998, this new law kicks in, and you can't be granted asylum if you apply more than a year after entering, or you can't prove when you entered, you snuck over the border without evidence of when you came in, unless you meet one of two exceptions to the deadline. There's one exception for changed circumstances, such as there's been a new coup in your country that suddenly makes it, you've been here for 5 years, but now there's a coup and now it's dangerous for you to go back. Or extraordinary circumstances, such as you were mentally incompetent for the first 5 years you were here and couldn't apply for asylum, or you were physically disabled to the point where you couldn't apply. You were in a coma for 5 years, and then you applied for asylum. There are a couple of other changed circumstances. So even if one of those exceptions apply, you have to apply within, quote, a reasonable period of time, whatever that means, after the exceptional or changed circumstance, occurs and the exceptional circumstance is no longer present. One of the principal recommendations of the book, based on the research that I'm about to report to you, is that Congress should repeal the deadline. And in fact, the U.S. Senate's Comprehensive Immigration Reform Bill, which was passed last summer, does repeal the deadline. But our House of Representatives shows very little inclination to pass a Comprehensive Immigration Reform Bill. So don't hold your breath for this deadline to be repealed. So what are the effects of the one-year deadline? On the whole, 30% of applicants who file more than a year after entering the United States, on the whole, 30% of applicants file more than a year late, more than a year after entry. Okay. On the whole, 70% file on time, 30% are late. But applicants from different countries have very different rates of late filing. So Armenians missed the deadline only 15% of the time, compared to 45% of Indonesians who are late. Okay, so 15% of Armenians are late, 45% of Indonesians are late, 34% of Chinese are late, but only 18% of Haitians are late. Any guesses as to what causes this difference in late filing among different nationalities? Yeah.
Language?
Language might be a possibility.
Except the Armenians.
Aren't so many Armenians who
Yeah.
speak English when they arrive, or Ethiopians.
People are sort of working illegally and then they get caught or something. And they're more propensity for sort of going in and doing something else as a sort of an economic migrant and then getting
That might be true of the Chinese in particular. The smugglers may discourage the Chinese applicants, the professional smugglers, may discourage them from filing on time to keep them in bondage until they pay off their debts to the smugglers. So that's a possible theory.
A preference to remain undocumented or undetected,
Why would different nationalities have different preferences?
based on likelihood
Of winning?
of money.
That's
Except the
fine.
Haitians always lose,
So-
and they're at 18%. I mean, I think that may be true in some circumstances, but it doesn't explain
Yeah.
everything.
I worked for DHS. I was at the Arlington Asylum Office, and when I was there, we were involved in looking at the Indonesians and a huge fraud ring.
Uh-huh.
So I would say that maybe it would take more than a year to put together a fraudulent application.
It should take less than a year.
Right.
Make it up, right?
Well, we're going to talk about the fraud ring later, actually. in my presentation. Yeah,
But
there's
the
one
fraud
more.
ring were good at this, so they were, filing applications on time.
Right, just got to photocopy it and send it out.
It's
Right?
access to paralegals working with the ethnic community.
Yes, that's our theory.
Right.
That Haitians are mostly in Miami. And in Miami, there's a Haitian support organization on just about every block in Little Haiti. So there are all kinds of organizations helping Haitians telling them there is a deadline, telling them there's asylum, telling them there's a deadline, helping them to apply. Similarly, in California, where most of the Armenians were settled, Armenians tended to go to towns where there are other Armenians and lots of people to help them. But the Indonesians were spread out across the United States more, and we think had fewer asylum support organizations. This is important because there's absolutely nothing in the congressional record or the hearings in 1996 that suggests that Congress had any idea that this would have differential application to different nationalities. They've talked vaguely about, oh, this will stop fraud, which we doubt it stopped. But maybe if Congress paid attention to the fact that this deadline was hurting Indonesians more than it was hurting Haitians or something, they might make a different decision. We also use this data about missing the deadline to do something called an out-of-sample prediction, which is a statistical methodology for figuring out how many people who were denied asylum on the basis of the deadline would have won asylum had it not been for the deadline. So what the computer did to do this assessment was it looked at the characteristics, all these characteristics that were coded, of every person who was denied because of the deadline, gender, nationality, age, and so forth, and matched those characteristics with somebody who won asylum, who was also late, but who qualified for one of the exceptions. So for everybody who qualified for the exception, the computer figured out a coefficient for them based on all their characteristics and applied the same coefficient to people who lost because of the deadline, but were just like them. And we were able to figure out that 14,000 applicants, and with dependents, that's 21,000 people over this 14-year period, were denied simply because of the deadline, but would have won asylum had it not been the deadline. A fact that has not yet impressed our Congress, apparently.
Sorry, can I just ask a question?
Yes, of course.
Were you able to find out how many of those applied for withholding of deportation?
No, because
Yeah.
so when you're denied, you go to the next stage, and an immigration judge can make an independent assessment of whether you qualify not only for withholding, but for asylum, right?
Okay,
And can make a different decision. And we know that sometimes they do make a different decision on the one-year deadline. But we don't know how often, because that's in the Department of Justice instead of the Department of
And
Homeland
their
Security.
computers
And the
don't.
computers don't talk to each other.
Okay.
So even the Department of Homeland Security has no idea what happens to its cases once it refers the cases to the Department of Justice.
We're working on it. We've been jumping up and down about this for 8 years now, but we haven't managed to get them to make their
Nice.
computers talk to each other.
And it wouldn't be that hard because they use the same code number for it's called an A number, for the applicant in both agencies. So all they'd have to do is do a little computer programming to get feedback on the A numbers that they refer, but they haven't done it.
And you wouldn't be able to analyse that independently?
We can't
Even if
unless,
it's confusing.
unless we get the data from the Department of Justice, which has been much less forthcoming with sharing data with us than the Department of Homeland Security.
That's interesting.
So you, as I mentioned, you can win an exception to the deadline. So one of the things we're interested in is, are these exceptions to the deadline doled out differently to different nationalities? And we discovered this is that if you are denied based on the deadline, it's called a rejection as opposed to a denial or a referral. Denial means a very small number of cases are called denials. Those are ones where the person's in legal status in the United States, but doesn't win asylum. The vast majority of the people who don't win asylum are not in legal status by the time they finish this whole process. They may be in legal status when they start it, but by the time they finish it, they're not. So about 95% of the actual denials are not called denials, they're called referrals, but if they're referred based on the deadline, it's called a rejection. And here's the rejection rate by nationality. Iraqis were only rejected 17% of the time. Liberians, these are late Iraqis. 17% of the time of late Iraqis were rejected. 20% of late Liberians were rejected. 32% of late Togolese were rejected. But over here at the other end, 75% of Ivorians, 77% of late Gambians, and 90% of late Mauritanians were rejected because of the deadline. Then you can put together the graphs, and this is in the book, I'm not going to show you this graph, but you can put together the rate of being late and the rate of being rejected based on lateness, and come with an overall loss rate by nationality. And it turns out, it's not so different from this, it turns out that 18% of all applicants are rejected because of the deadline and actually lose because of the deadline, 18%. But Iraqis and Liberians were actually rejected based on the deadline only 5% of the time, while Gambian applicants topped the list and they were rejected, that is late and not qualified for an exception, 58% of the time. Huge difference, 10 times as much. All right, enough about the deadline. Let's look at the merits. So, talking about now 329,000 of the 383,000 cases. 329,000 were not rejected because of the deadline. That's the 82% were not rejected. So 329,000 met one of three criteria. Either they applied before 1998, when there was no deadline, or they applied on time, or they applied late, qualified for rejection, for an exception. So we find that we looked at this by year, and we broke the eras of this 14-year period into 4 pieces. So the first part is from October, when the study starts, October 1st, 1995, to June 16th, 1998, when the deadline took effect. 30% grant rate. The second is from when the deadline took effect to 9/11, 56%. From 9/11 until a new law was passed in 2005, which officers were trained on by July 1st, 2006, called the Real ID Act, which tightened the qualifications for asylum. It provided that if you didn't corroborate your claim, the asylum officer had to reject your claim, unless the asylum officer believed that corroboration would be too hard to get, would be unreasonable to make you get. So there are a couple of countries like Eritrea and Iraq during Saddam's period where getting the data out of the country, North Korea, would be just impossible to get. So the officer could excuse you for a lack of corroboration if it was impossible to get the corroboration. Otherwise, he had to reject you. So that took effect at the end of this period, and the last period is from 2006 to the end of the study. So we see that there's a huge increase in successful applications after the deadline takes effect, and a big drop-off after 9/11. So what accounts for this? Well, one of the things that we think accounts for this big increase after the deadline takes effect is that people are. So there's another thing that happened in 1995. Beginning of 1995, a new law takes effect that says that while your application is pending, you can't work in the United States. Until January 1st, 2005, you could work while your application is pending. Starting in 1995, you can't. And we think it takes a couple of years for people to understand this and to stop applying, to stay underground, because if they have weak cases, there's no incentive to apply. They're just going to get put into removal proceedings and deported. So it takes a couple of years for word to get out to the community. And after that, people with good cases still apply, but people with the weakest cases, we think, don't apply. And when people with stronger cases apply, the grant rate, of course, should go up. So we think that accounts for this. And then 9/11, there's a sudden drop-off. So why? 56% down to 46%. Well, one possibility is that asylum officers were just as affected by the rest of the country as were just as affected as anybody else in the country by fear of terrorism and general distrust of foreign nationals and concern about them. But there's a particular reason why asylum officers may have been especially concerned. And that is that a few months after the attacks, the then Immigration and Naturalization Service, INS, the predecessor of DHS, sent a visa renewal to Mohammed Atta, one of the architects of the attacks who had died on one of the planes crashing into the World Trade Center. So after he was dead, they sent him a visa renewal. And as a result of the uproar over this, which made all the papers, and congressional hearings and so forth, 4 top international affairs officers of INS were fired in what became known within INS as the massacre. And the commissioner of the INS, Ziegler, sent out what became known as the zero tolerance memorandum, which said, effective immediately, I am implementing a zero tolerance policy with regard to INS employees who fail to abide by headquarters issued policy and field instructions. I would like to make it clear that disregarding field guidance or other INS policy will not be tolerated. The days of looking the other way are over. Individuals who fail to abide by issued field guidance or other INS policy will be disciplined appropriately. We understand some officers interpreted this memo to mean that referrals for deportation hearings were a lot less risky to one's career than granting asylum in a marginal case. So this may have accounted for some of this. Another thing that happened as a result of 9/11, where there were many more security checks, and FBI started sharing more data with the department, with INS and then the Department of Homeland Security. So if a person had made a prior entry into the United States under another name, and the FBI had picked this up from fingerprint data, for example, or if the CIA had some information that the person was a suspect, this would be now transmitted to the asylum officers. Now, we also did a study of grant rates by gender over a period of time. And this chart shows the results of that. And what you see in this chart is that in the first 2 years of the study, 96 to 97, fiscal 97, ends October 1998, men and women win at about the same rate. But in every other year, women are red, men are blue, in every other year, women win at a higher rate, 32 to 38%, 50 to 57%. On the average, women won asylum since 1998 at a rate 12% higher than men did. So why is there a difference after 1998? Why is it the same in those years and different every year after? Well, our hunch is that it should have been like that in 1996 and 1997 as well. That women are more frequently persecuted than men and have more severe persecution. But something changed. So actually a couple things changed. First, in 1995, INS issued informal, non-binding guidelines on gender cases, gender-based cases, to the asylum officers. And there were 2 things in the guidelines. One was it educated the officers about sexual assaults and about this form of persecution, which more often occurred to women than to men. And second, officers were instructed on how sensitively to ask questions about sexual violence. And so we think that one of the things that changed this picture after 1997 was the officers had better training. The second thing that happened was that there were 2 cases that received a lot of publicity in the United States in these years. In 1996, there was the Kasinga case, which established that female genital mutilation was a basis for asylum. And about 2 years later, there was a case called R.A., which adjudicated whether a woman who was the victim of domestic abuse could win asylum, where the government of her country was inactive in prosecuting or deterring domestic abuse. Now, Ms. R.A. actually lost that case, but there was so much publicity about it and so much attention to the violence done by boyfriends and husbands in Latin America in particular, that the asylum officers became sensitized to this issue. And despite Ms. R.A. having lost her case in the Board of Immigration Appeals, the asylum officers, at least in many regions of the country, started granting these cases. By the way, there's already one case about 12 years later, but not in a precedential way. That issue is still open in the United States, but the government, after 12 years of fighting her, gave up the letter of asylum. Any questions so far? Okay, so the next thing we did was we took these 4 years. What we wanted to know about was how did the grant rates of the asylum office correlate with human rights conditions in the countries from which the people came. So, in principle, if a country had a worse human rights record and engaged in more violence against its citizens, the grant rate for nationals from that country should be higher. How do we measure human rights conditions? Well, we used the Freedom House Index of Human Rights Violations. Freedom House rates every country on a scale of 1 to 7 for both political and social rights. And you could add the two scores and you get a score from 2 to 14, where 2 was the best democracy and 14 was the worst dictatorship, right? And in order to make our findings, clear cut, we counted as a worst abusing country only those countries that had a score of 12, 13, or 14 in the year before the applicant came to the year before the applicant applied for asylum. In other words, the year the applicant was most likely to have fled. So, red here shows the worst abusers, yellow the less bad abusers, and we see that in every era, the asylum office was actually granting asylum at a higher rate to people from the most abusive countries. So this is pretty good validation that the asylum office is doing a good job. It's not random, right? They're not just randomly granting or denying cases. But one other interesting thing about this chart is that the rate of the grant rate, while the rate falls as a whole from after 9/11, the grant rate from the most abusive countries falls a lot faster than the grant rate from the less abusive countries. Any guesses as to why?
Because you recently invaded. Because you recently invaded them.
So who are these most abusive countries?
Because of the Afghanistan, Iraq.
A lot of them are Muslim countries, and the fear of Muslims takes over the United States. Pakistan, right, takes over the United States right after 9/11. I can't underestimate the degree, I can't overstate the degree of panic in the United States. We start calling in all the Muslims who are in the United States for special registration. All kinds of things happen. And this is perhaps one of the small effects, unappreciated effects of 9/11. What about the characteristics of applicants? Here. Turn it over to Jay.
All right. So we'll talk you through some of the characteristics of the applicants that had an unexpected impact on the grant rates. So whether or not an applicant has dependents, minor children, spouse, with them in the United States is legally irrelevant to whether or not they qualify for asylum. But applicants with dependents with them in the U.S. want asylum at a rate 18% higher than those without dependents. And the differences are even greater for applicants from certain countries. For example, the grant rates for Guatemalans is 82% higher than the rate for Guatemalans without dependents. Any ideas why that might be? Why are we seeing folks with dependents, particularly from countries like Guatemala, more likely to be granted asylum?
It's domestic violence issues, is it? That motivating the claims.
Some of the claims, certainly, but I think probably not enough to make that large of a difference. Any?
I would think that a lot of the people from particularly Guatemala would have come in maybe the 1980s, so they would have had children in the United States who would have been American citizens, So if they rejected the parents, then the children would either be abandoned or be.
So, but those, that is a good point. But I think two things about that. First of all, those folks probably aren't included in our database. They would be dealt with separately under the settlement, the American Baptist Church's settlement. And if they're U.S. citizen children, they wouldn't be included on the asylum application.
Right.
So these are children who don't have status in the U.S.
Also, anybody in the 1980s would be 15 years late, at least 15 years late, right, in applying for asylum, and they're not going to win.
Mm-hmm.
Is it that the ones with children are more likely to have connections in the community and therefore access legal advice?
Could be. So we got various theories from the asylum officer on this. One of them was that people with children are just more likely to take the time to prepare their applications well because they have a lot more at stake than just themselves. So that was one of the perhaps more legitimate explanations. One of the very human explanations that we heard from asylum officers was you have to ID the kids when you go through the process, which means the kids have to come in and you have to make sure they are who they say they are. And if your applicant has a family, you're just, as a human being, more likely to be sympathetic to them. Part of that may be that they prepared their claim well. Part of it may be that it makes them look more legitimate, right? If you're fleeing and bringing your family with you, it's perhaps more likely that you're at risk. But I think there are a lot of factors at play that make this happen. All right, so we also saw the impact of status at entry, so whether these folks entered with a proper visa or not, or came over the border, and representation. So having a representative made a difference on the whole. Those who did not have representatives won 42% of the time, while represented applicants won 50% of the time. So we knew this, we expected it. It's not a surprise that represented applicants win more often. Other studies have showed this. But here's an interesting fact hidden in the aggregate statistics. It turns out that representation has made a slight difference for inspected applicants, but a much greater difference for those applicants who came across the border without a visa. So some asylum officers suggested to us that State Department consular officials only give tourist and student visas to people with substantial needs, right? So wealthier people who tend to be better educated are these folks here. They come with visas. They may be less in need of lawyers. They may be able to articulate their claims much more easily without a lawyer, whereas folks who are smuggled over the border, this group are much less likely are likely to be poorer and less educated, less able to articulate their stories in a way that would be cognizable by the asylum officer. So lawyers may be of greater assistance to these folks than they are to the more educated applicants. All right, so this one is a doozy. So this came out of our meetings with asylum officers. So one asylum officer, and I'll quote him, surmised that the group with the lowest grant rates would be unrepresented males without dependents who entered the United States without inspection, right? These would be viewed with the most suspicion. These are the people we think of as economic migrants. These are the people who we think of maybe as persecutors of others or as terrorists, right? This is the group that we're most concerned about. Lacking lawyers, not being represented, they would be at least able to allay the suspicion that, or to view it as this asylum officer did, they would be unassisted by a representative who would somewhat mediate the threat, right? So
his words, somewhat mediate the threat.
Right. So the officer suggested we do a study by gender and representation of those applicants who lacked dependents and entered without inspection. I'm sure he did not expect we would come up with this when he did so, but we did. And the results support the officer's hypothesis. Unrepresented males had the lowest grant rate among uninspected applicants without dependents. That's them right there, the 29% grant rate. While represented females had the highest grant rate among this population. So represented females here are, where are you at?
Bottom right.
Bottom right. Represented females are 45%. 45%, right?
Uninspected, but the inspected are 56%.
But the inspected are 56%.
The highest of any group.
So they're the highest of any group here, right?
So look at the difference between the 29 and the 56, Right.
So that's a
So-
93% difference, right? So women who entered with inspections and had dependents wanted this 56% rate, while the men without inspection, no dependents, at a rate of 29%. So another way to think about this is having a dependent made no difference at all for represented females, right? This was having a dependent didn't matter to those females. By contrast, having a dependent made a great difference for unrepresented, uninspected applicants. These folks here, these males having a dependent made a much larger difference, and on the female side as well. So these asylum officers' words come true in visual form. So let's take a look then at what happened at the regional asylum offices. And your comment earlier will come into play here. So we found large differences in grant rates across the asylum offices. San Francisco, Los Angeles, and Arlington have the highest grant rates overall. These differences persist even when we drill down into particular nationalities. So here we looked at the rates of regional offices that had adjudicated at least 500 cases of nationals from the country in question. Here, in this case, Somalia. The grant rate in Chicago for Somalis is 34%. The grant rate in San Francisco is 89%. So some pretty startling differences, even when we look just at one nationality. And we had this East Coast, West Coast divide. Grant rates on the West Coast seem much higher than corresponding rates on the East Coast. I'm originally from the West Coast, so maybe it's just because we're happier out there. I don't know. So for Indonesians, the rate was 20% in Newark and 54% in San Francisco. For Russians, it was 28% in New York and 65% in San Francisco. So this could be because of Operation Jakarta, which you were talking about before, this fraud ring related to Indonesians. And we know that it was based in the Mid-Atlantic, but we know they also filed applications on the West Coast. So it may be part of the explanation. I'm not sure it's the entire explanation. Any ideas why?
Certainly wouldn't affect the Russians.
No.
Any ideas why we see this coastal divide?
I mean, did you interview the regional officers?
We did,
So,
yeah.
And this may cross-reference some of your other data in terms of the experience of the officers, the jadedness of the officers, the culture in the offices may vary enormously. I mean, expectations can be hugely different, can't they? And I guess the economic sense of the place as well. You know, are we a growing, hungry for immigrants sort of part of America, or are we a suffering, sort of declining, Rust Belt area where there's a lot of competition for jobs? I don't know, all those things may somehow feed into the culture of the offices.
Yeah, absolutely. My view is that it's a cultural explanation. There are enormous differences in the cultures of the office. Even frankly in the physical space of the offices. I didn't visit all the offices, as I said, with my co-authors, but we went to the different offices. And the difference between the physical Newark office and the physical San Francisco office could not be more striking. The Newark office, we presented this in a windowless, scruffy room. It's just kind of like what you think of when you think of strip mall America. It's in the middle of nowhere. Vast parking lots are all you can see, right? I suppose it's commuting distance from New York City, but it's not lovely. The San Francisco office is in the middle of downtown San Francisco in this glamorous window. We were in this enormous conference room that they share the building with the EPA. The whole community, the director of the office invited the entire community. The room, standing room only, it was packed. The other thing that came out at that San Francisco office was that they said San Francisco not only has a lot of free representation, because obviously New York has a lot of free representation for asylum seekers as well, but they have a lot of other support services. They have psychological services. They have all kinds of support for these communities. And so they think that the applications, and we heard this from people who worked at both the San Francisco office and other offices, they said that the applications are just much, much better prepared in San Francisco than they are at the other offices.
On the other hand, that doesn't explain the whole thing, because Los Angeles is number 2. And Los Angeles,
Right.
the officers were scornful of the representation in that city, and for good reason. They told us that there are a lot of non-lawyer preparers in Los Angeles who help prepare these applications for people, charge them a lot of money just to prepare the application. And they're the people who work with the applicants. The lawyers come in and are met by the preparers in the parking lot of the asylum office, and the asylum officers watch them out the window as the preparers hand off the file to the lawyers who have never met the client. And then the lawyer comes in and sits on the interview but never says a word and collects a fee for having represented the person at the asylum officer.
And those are the lucky ones for whom the lawyer shows up, right? Right. The other cases, the lawyer doesn't show up.
Is that a private fee? It's not.
What?
It's just a fee that the lawyer charges the client.
Yes,
Yes.
Sort of hand-holding thing, and
Yes.
charge a good fee for it.
yes. Typical asylum case, we're told, is $8,000 if it doesn't go to the immigration court, and another $15,000 to go to immigration court. And gosh knows how much it costs to go to the circuit if you go to the BIA.
All right, so let's next take a look at disparities within regional asylum offices. And here again, looking at only at officers who decided more than 100 cases. These cases are assigned randomly within the offices, so we should see some similarity in decision making. So in Newark, here we do not see a lot of similarity in decision making. We see great disparities in decision making over the period studies. There were 80 officers with at least 100 cases. The average grant rate here is 32.5%, but individual grant rates range from 2.5% to over 90%. So there were enormous disparities.
These cases are randomly assigned to these offices.
There is somewhat less disparity when we looked at only the most recent 3-year time period of our study. That's a time frame after our other book, Refugee Roulette, was published and showed great disparities. But still, the grant rates in Newark range from about 10 to 55%. So large disparities here.
Is that controlled in any way then for the type of cases?
That is not controlled for. The assumption is because they're seeing 100 cases, they're assigned randomly, they're going to get a similar mix of cases. But
is that a valid assumption?
We think so.
If an officer has been given 100 cases, 50 of which are from a country where the grant rate is poor generally.
Sure, but that doesn't happen because of the random assignment.
Okay.
In fact, we have much larger databases in the book Refugee Roulette, which show for immigration officers, we have every officer in the country who heard 100 Chinese cases, and so it's a huge database, and it's a slope very much like this one.
Oh, okay.
yeah, and it shouldn't happen because the cases are assigned randomly. So if one officer gets 50 cases from that country, the other officer should be getting, 50, 53, 40 something, right? Something like that.
So is there did you ever hear of any disciplinary action or even slaps on the wrist if you're in the same office and you're at either end of the spectrum? Was there talk of being pulled in and...
So that depends, and this is one of the things that we didn't have the data to study. We would love to look at it further on the supervisory asylum officer and how they view high grant rates or low grant rates. And we did hear, that there could be some clashes if it's supervisory asylum officers thought you should be granting more or you should be granting fewer cases. And actually, one of our recommendations from our prior book is that these two people, the low grantor and the high grantor, should actually be forced to sit and talk to each other and figure out why they're looking at these cases so differently. That's a very easy, not a complete solution, but a way to address.
But the directors of the offices are quite reluctant to tell people you're granting too many cases or you're granting too few cases, because they are worried about being criticized for political interference. So they signal in not by doing this directly, but by remanding a certain number of cases for another look by the officer who decided them. And maybe an officer will get a clue that they're getting a whole lot of cases remanded, that they should be looking at the cases differently. On the other hand, that doesn't take very well. And culture may play a big role here. We can't know this because we don't know very much about the officers. But we know more. So in Refugee Law, we did a study of we had a lot of background information on the immigration judges because their bios are published on the web. And we have a graph in Refugee Roulette that shows that a lot of the officers had never been in prosecution of cases before becoming an asylum officer, before becoming an immigration judge. Whereas a large number of other officers had been in prosecutorial roles, for example, prosecuting immigration cases for the Department of Homeland Security or for the Justice Department before becoming a judge. And we showed that the highest grant rates were for the judges who had never been in prosecutorial roles, and that the grant rates went steadily down for every year that the immigration judge had been in a prosecutorial role before becoming an immigration judge, which tends to show that the culture could be, there are two explanations, right? One is that the culture of the prosecuting agency infected the person, and the person absorbed that culture and carried it over into being a judge. The other explanation is that a person with a prosecutorial mentality went to work for the prosecuting agency and carried that pre-job prosecuting ethic into the job as a judge. And we don't know whether it's correlation or causation, but we can show this direct, very dramatic, direct straight line graph.
There's a question.
It's sort of been answered, but it was the degree of politicisation and self-scrutiny that the supervisor or whatever, how do they specifically sit and work through them, or is it sort of not for those particular reasons?
So every case has to be approved by the supervisory asylum officer.
Okay.
So yeah, so that's the process he was talking about. But every case before the grant is made final goes through the supervisory asylum
And do they
officer.
have, sort of, I don't know, annual audits or whatever, where they go through their figures and have to work out what the rates are and that kind of thing, or it's sort of not? They don't, that's sort of, an internal sort of auditing system, if you like.
Put it like this, our data was shocking to all these people.
Yeah.
They didn't know it.
That was my thing.
Right,
Yeah.
right. We are the audit system.
Yeah.
Exactly. All right. So this next one is.
Jaya, I'm afraid I'm going to the audit system on you. You've got probably 15 minutes.
Okay. Excellent. We will squeeze through quickly, so there are time for questions at the end. This is Phil's favorite slide of all, which we call a box plot. So it shows variations among individual officers within all 8 regions. The black line in the middle of the box is the median grant rate for each region. The red box shows the range of rates for the middle 50% of the officers from the region. And then these black lines extending further out show the full range of rates for officers from the regions. The extreme outliers are represented by circles. So this is just for the last era 4 from 2006 to 2009. So this is not significant because we didn't have enough cases from Houston. But the other lines show that there was a great deal of disparity even during the last 3 years of our study. So we did this so the comings and goings of officers over time wouldn't have a big impact. There wasn't too much disparity in Arlington or in New York, but if you take a look down to Los Angeles and Miami, you see a lot of disparity both in the middle 50% and among all officers. All right, so our next slide just takes a look at single nationalities within an asylum office. This is the largest population by nationality in these offices. So Miami, the largest group we have there are Haitians. There are 85 officers with at least 100 Haitian cases. The average grant rate is 34%. And here our grant rates range from 5% to 85%. This may be a result of some peculiar happenings, but even if you disregard that, it's a 70%, ranges from 70% to 5%. Los Angeles, Chinese were the largest population there. There were 67 officers who decided at least 100 cases. There, the grant rates range from 1% to 99%. So about as broad a range as you can imagine. All right, so let me jump in to officer characteristics so that you guys have time to ask some questions at the end. So this is only based on 31,000 of our cases. These are officers that Phil talked about that were trained at the Federal Law Enforcement Training Center, 221 officers on whom DHS had collected demographic information. So first, a question for you. What do you think happens to grant rates the more cases an officer has decided? Do you think their individual rate of grant
goes down?
Goes down. Goes down. That's exactly what we assumed, and that's exactly
this first graph you're going to see is all 329,000 cases.
Right.
First graph is not 31,000.
This is all 329,000 cases. So it actually went up. And that was exactly what we thought. We called this jadedness, we called this the jadedness factor, and then we had to change it because it's the opposite of jadedness, right?
Case softening.
Case softening, case softening. So we assumed, as you did, officers who repeatedly heard these stories of persecution and torture would become jaded, their grant rates would go down the more cases they decided. So in fact, officers, we see this generally goes up with experience, right? Officers who've decided more than 1,000 cases, these folks here, 58% grant rate, the highest grant rate of any group. So that was quite an interesting and surprising finding. We can talk about this a little more in the Q&A if folks are interested. We also found that gender really made much less of a difference for asylum officers than it did for immigration judges. One of the big findings of our previous book, Refugee Roulette, was that in the immigration court, there was quite a large difference in grant rates between female and male immigration judges. Very little difference, 47 to 46% between male and female asylum officers. So we don't know what contributed to these factors, but perhaps because there's a lot more training in the asylum office, perhaps because of the selection, again, the pre-existing culture of the officers, there's not so much difference between men and women. We also looked at grant rates by representation and officers' ethnicity. As I've said before, on the whole, applicants who were represented won asylum at about the same, this is based on the smaller, the 31,000 database, about the same rate as those who weren't represented. 47% for those who were unrepresented, 46% for those who were represented. But while white officers granted asylum at a higher rate to those who were represented, all of the minority groups, the officers who self-identified as minorities, Asian or Pacific Islander, Black or Hispanic, those are the terms that are used in the sheet that they have to check, which is why I use those terms, they granted asylum higher to those applicants who were pro se, who were unrepresented. So we thought that was quite an interesting finding too. We have no idea why this happened. But there's also an interesting relationship between ethnicity and law degrees. So for officers of all ethnicities, those with law degrees had higher grant rates than those who did not have law degrees, but the most striking differences were among officers who self-identified as Black or Hispanic, right? These are those with law degrees, these are those without. There was a much bigger difference among those groups. Again, we don't know why this happened. Some more analysis of officers' education, how having a JD informs decision-making. It made a difference in terms of the country of origin and the human rights conditions. So this is this chart on the left. So for folks coming from countries with more severe human rights conditions, there's really not a big difference between those with a law degree and those without a law degree. But if we look at folks coming from countries with less severe human rights conditions, officers with a law degree grant asylum at a higher rate, right? A rate of 50% rather than a rate of 42%. Perhaps this is because when the human rights abuses are more obvious, The officer's postgraduate training doesn't matter as much because it's likely the applicant is really a refugee. But when an applicant comes from a country with a more mixed record, the asylum claim is more complicated. Officers with a law degree may be more likely to see how they fit within the framework of the Refugee Act. We also see here the difference in Latin America. For applicants coming from Latin America, officers with a law degree grant at a rate of 52%. Those without a law degree grant at a rate of 31%. Again, this may be because we see more non-traditional claims coming from Latin America based on domestic violence, based on gang members as persecutors, that officers with a law degree might be more likely to tease out than officers without a law degree. Remember, under great time pressure, right? The officers are adjudicating these cases under great time pressure, so the law degree may give them both the ability to fit these stories into the legal framework more quickly and to have the confidence to go forward and take that as a grant to their supervisory asylum officers because they understand the law better. So here we take a look at grant rates. This is our last graph, grant rates by officers' education and applicant representation. So for applicants with representatives, it didn't matter whether the asylum officer had a law degree or not, right? These are represented folks, same 46% grant rate. But for those without representatives, it did matter, right? For unrepresented applicants, those officers with a JD granted them 51%. Officers without a JD granted them at a 41% rate. Again, it may be that what's happening here is that for those who are unrepresentative, officers with a law degree, and these are what asylum officers, the explanations asylum officers suggested to us, maybe have more training in interviewing techniques and getting out the story in a way that can be translated into the legal framework that they need. All right, so last slide, our policy recommendations. So based on the data analysis in the book, we suggest a number of policy recommendations. Here are just a few of them. So the first is to repeal the one-year deadline on applications. We think it wastes government resources, results in the rejection of many genuine refugees, and as you saw, disproportionately affects certain nationalities as well as women in unfair ways, and just isn't that successful in weeding out fraud, which is its purpose. So we think that Congress should get rid of the one-year deadline. We think a law degree should be a requirement for future asylum officers. We think the most effective way to eliminate disparities would be to require the government to provide legal counsel to all asylum seekers, but that is not going to happen in my wildest dreams, right? Those are not the kind of resources that the U.S. government is going to be willing to devote to the asylum process. A substantially less expensive approach would be to hire folks with law degrees. This would help to level the playing field. So, of course, even though it's a pipe dream, we say that we should provide indigent applicants with free representatives. One thing that may actually go forward is starting with particularly vulnerable applicants, right? There may be funding out there for unaccompanied minors, for folks with mental disabilities. And one more recommendation that's not up here, and that we really heard repeatedly when we went around and talked to the asylum officers, is they have to make these very difficult decisions on a daily basis, and they are getting less and less time to make these decisions. So as we talked about the security checks increasing after September 11th, they now have to run those security checks in the same amount of time, the same 4-hour slot that they had before they were given the security checks, right? So there is less and less time for them to decide cases, for them to think about cases, for them to write up cases. And we think that that's both unfair to the asylum officers and doesn't make for a well-functioning system, so that they should be given more time to make these important decisions. All right, so let's get some questions from you guys in the little bit of time we have left.
I know we've got a couple of minutes, so should we take a couple of questions first? And take them together, and then if you'd like to respond to them in that format. Okay.
Sounds great.
Good, yes, you've got your hand up.
In relation to your last point, do you know what the targets for the asylum officers actually are? And also, are the targets the same all over the U.S.? Or do they vary by office?
Targets in terms of their grant rates?
And
No,
targets in terms of the cases
number of
that they are
cases.
assigned.
Oh, in terms of the number of the cases.
14 a week, I think. It's 14 a week or 18 a week? Something
Yeah,
like that.
it's something, I'm pretty sure we have it in the book somewhere, I can look it up and get it to you.
It's
but
actually in the
it's
GAO study. On the web, you'll find, if you look for GAO, that's Government Accountability Office, 2008, I think it is,
Yeah.
study of asylum officers. I think you'll find the target figure in that study.
But do you think it's around 14?
I think it's about 14 a week.
Is that to conclude or just to interview?
Do everything. All the interviews, the security checks,
background reading,
background reading.
write-ups.
And remember, the good cases have 500 pages of documentation attached.
And they get 4 hours too.
4 hours is...
And write-up of the decision.
What's the 4 hours for?
Everything,
Everything.
per case.
Security
Okay,
checks.
because I'm just trying to do the math there. If you've got 4 hours and you've got to do 14, that's 56 hours.
Right, but if you have a case that's past the 1-year deadline, that doesn't take you very much time.
Okay, so there's a proportion you can knock out as sort of inadmissible, effectively.
Well, but maybe you shouldn't be knocking it out. Right? If you really search for an exception to the deadline, maybe it shouldn't take you 20 minutes.
Okay, other questions? Yes.
Yeah, thanks. Very, very interesting, and there's a lot of connections with your previous book as well. The key issue, which you were sketching out when I entered late, my apologies, was the significant factor of non-legal issues, gender, striking out representation issues as well, right? Number of dependents and things like that. Presumably you've had discussions with the different bodies about the effect of these. What did they suggest was the way forward in dealing with these kind of disparities and the way that justice is served?
Okay, can we park that question? Just see if we've got another one that we can link it up to. Yes.
It was just, you mentioned the issues of the getting data from the Department of Justice and stuff. It was generally what's the reaction been to the research and in terms of Department of Homeland Security in doing the research in the first place and help hindrance, politicisation, whatever.
Okay, any final? Yes. Yep.
For me, and maybe for you, the most striking statistics was the disparity in grant rates between different offices, both within the same faculty building, and obviously also disparity between, also quite big between the different district offices. Have you managed to dig into that a little bit more and try and work out how it is that these officers and these see the world so differently? You know, what is going on in their qualitative reasoning processes that is so massively different about who they basically is. It things like probably it's credibility. You know, who do you believe? Generally, that's what it comes down to. And why is that?
Yeah.
Okay, last question.
Is corruption an issue?
Good question. Which to finish. Okay. You've got 4 fairly
So
wide-ranging.
the first 2 questions are related. What did they suggest, and what is the reactions to the research? We'll start with those. So the asylum officers at the lower level, the people who are actually making these decisions, were quite reluctant to make policy recommendations. Their directors were there while their office directors were there while we were speaking, and they don't feel like they have much of a mandate to speak to large policy issues. The national directors in the national office, however, felt less constrained. And what they said when they saw this, the national director saw this presentation 4 times. And what he said when he looked at the last set of slides was, lawyers are the great equalizers. So I think what he took away from it is that it really makes a difference to whether these asylum officers are lawyers. But he also said there's no way he can get the congressional appropriations and the Office of Personnel Management to make a change to require lawyers in all the offices, because that's a higher GS level and a higher level of pay. The San Francisco director, however, has found a way to do this. She only hires lawyers. So I think that the other directors could do it if they figured out how.
And then one thing we did hear more from the lower ranking officers was more time.
More time.
We repeatedly heard more time. We just need more time to do our jobs well. So that's why it's one of our main.
As for reactions, the national office is very interested in
This is the
data like
Department
this.
of Homeland Security.
The National Office of the Asylum Office at the Department of Homeland Security. The director, the deputy director, the top brass, they think this is wonderful free research for them. And they didn't pay for this. This is totally done independently. And they're very pleased to have the results of the study. It informs them and they want to do a better job. So they're very happy to share data.
They've been
with us.
remarkably committed to kind of transparent government and, learning what's going on so they can address it, which is wonderful.
The other questions were, why are these disparities? Why are the
That's a great question, and there's tons about this in the book that I wish we had time to go into in the qualitative questioning. I think you're right. I think it's about credibility. I mean, it's fascinating to see the quotes from different people who took the survey who just see the world so differently. One of them says, the best part of my job is, that I feel like, even though it's an incredibly difficult job, I feel like I'm saving people's lives and I'm making a difference. And others who say, like, it's just fraud, day in and day out, just fraud. It's really, just an enormous range in the way folks view the world. And, I think there are a lot of ways to fix this. I think more time, because the less, studies show that the less time you have to make a decision, the more likely it is to be a decision based on gut instinct rather than rational analysis. More time would make a difference, more time for training, more time to sit and talk to each other and understand why your colleague is granting it a 99% rate or why your colleague is granting it a 1% rate. So I think, these are not enormous fixes, but they have not yet happened.
Corruption. There have been a couple of infamous cases, prosecutions of asylum officers cooperating with smugglers' rings and being paid off, but I think it's a very, very small fraction of. At any given time, there are about 220 asylum officers, and I think that the number of people who are corrupted or taking payoffs is tiny, and it does not enter into this study.
Yeah, I think it's very small.
Can I just follow up with one more question, since your presentation was about it? I know you and your missing colleague, I believe, has been involved very much in lobbying around the one-year deadline. It would be very interesting to hear. I know the Senate has picked up on this and Congress hasn't. Could you give us a little bit more background about what you've tried to do and the kind of reception you've had in this lobby?
Can we turn the video off at this point to answer that question? Since it's a very political call.
I'll tell you what, maybe it's easier, if that's something that you've got a particular interest in, unless everybody would like to. I know that we're 5 minutes over. Who would like to? Okay. We can probably, okay.
Do you want to round up for the video?
Okay, and then we might take that later, if it's really so controversial.
Yeah, we'll do it later.
Okay. Good. Well, thank you very much for
Thank you so
attending.
much for
Okay.
presenting.
Well, listen, I wanted to thank both of you, and just as this is the last in our series, firstly to congratulate you for what really is, I think, an eye-opening piece of research, and I think all of those around the table, most of us actually researching in the field in this particular area at the moment, see this as really a model of the way that this sort of research can be carried out. And also the presentation, which I think was wonderfully delivered as well, terribly engaging. So thank you both very, very much for your contribution. Great way to end the series, and we hope you found the questions and conversation interesting as well. And perhaps we can now turn off the video and draw you on some more contributions.